Hello, everyone. Welcome to the 18th episode of the TCLF One-on-One series. Through the One-on-One series, we aim to interact with the best legal professionals from India and abroad. And we're thrilled to have Professor Ryan Abbott as our guest for the 18th episode. Professor Ryan Abbott completed his bachelor's in science from the University of California, Los Angeles, and an MD from the University of California, San Diego School of Medicine. He then went on to finish his JD from the Yale Law School in 2016 and thereafter completed his PhD at the University of Surrey School of Law. Professor Abbott is a licensed physician, patent attorney and acupuncturist in the United States and a solicitor advocate in England and Wales. He is also a mediator and arbitrator with JAMS and has worked on contentious and non-contentious legal matters pertaining to the life sciences and high-tech industries. Mr. Abbott is currently a professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the Geffen School of Medicine at UCLA. Professor Abbott has published widely on issues pertaining to law and technology, health law, and intellectual property in prominent legal, medical, and scientific books and journals. He has also given several keynote lectures and presentations at international platforms like the WIPO, the WTO, and in universities like MIT, Stanford, and Oxford, to name a few. He is also the author of The Reasonable Robot, Artificial Intelligence in Law, published recently in 2020 by the Cambridge University Press. Managing Intellectual Property magazine named him as one of the top 50 most influential people in intellectual property in 2019. It's a true honor to have you here today, sir.
Well, thank you, Tati. It's very exciting to be here, and thanks for the overly generous introduction.
Yes, in fact, it's extremely interesting because, as I mentioned earlier, you have studied a very unique combination of subjects, both law and medicine. As my first question, we were wondering, could you tell us more about your journey in the legal profession and what prompted you to take up law after your undergraduate studies?
Well, I grew up in a family where my dad was a lawyer and eventually became a law professor. He's still a law professor at Florida State University. And so I was pretty familiar with the legal profession as a career choice. I went to UCLA as an undergraduate because I wanted to go into film, and that didn't last very long. And I was into Oriental medicine and Oriental philosophy. I broke my knuckle doing kendo, and an acupuncturist cured it and said, well, if you're looking for something to do, why don't you go to acupuncture school? So I said, well, that sounds fun. That should take like 3 weeks. But it was a 4-year program in California. And when I got done with that, everyone said, well, you're so young, you should go to medical school. That would be like the natural next thing. So I got in there, and then kind of midway in, I'm like, I think I want to be a lawyer. You know, never too late to make these decisions, I suppose. But I was coming out of school with an MD, a JD, and an acupuncture degree, and looking around at what to do. And someone said to me, you have too many degrees to do anything other than academia. And I said, that kind of sounds right. So I went into being a law professor.
That is a very unique journey, but you also have been a mediator. So I think you are in touch with the practical aspect as well, which is quite a unique combination of both academic and practical experiences.
No, I do practice, increasingly these days. I'm also a partner in private practice at a litigation boutique in Los Angeles, and working as a mediator or arbitrator. In England, I think they're much more encouraging of academics having practice backgrounds or also practicing. It informs teaching and research. I think in the US, there's more of a division between people who are purely academic and people who are practicing.
But I agree that it does give a very unique perspective on law from both the academic side as well. And on the topic of academia, congratulations on the publication of your book, which is titled The Reasonable Robot, Artificial Intelligence and Law. So your book covers a variety of topics, including AI's intersection with tort law, taxation regimes, criminal law, and patents. Could you highlight the key issues that you have studied in your book and also the conclusions you came to?
Sure. Well, my interest in this topic came about in around 2014 when I was doing some work in the life sciences and finding that there were vendor companies that were offering to do research for pharmaceutical companies and at least claiming that they had AI that they would use to help invent things. For example, they would screen antigens, which are therapeutic targets like a section of COVID-19's virus against a library of many antibodies and help select the antibody that would best treat that particular viral pathogen. And I was thinking, at the same time I was teaching patent law and thinking, if a person did that, that would make them an inventor on a patent. So I wonder what happens if a machine functionally invents something. And I wonder if anyone's ever thought about that. Well, it turned out people have been writing about it for at least 50 years. But I was just sort of struck by how you were having machines do human-like sorts of things in ways that they either hadn't done before or they hadn't done before at commercially relevant levels. And then thinking about how the law treats those two things differently. And it turns out if you look around in different areas of the law, behavior by people and behavior by machines often vary differently, even when it's really the same sort of behavior. And it turns out that this sometimes has negative consequences that really get in the way of the law accomplishing what it's meant to accomplish. So my book argues that really the law would do a better job of achieving its goals if we did less to discriminate between AI and human behavior. And I call this the principle of AI legal neutrality. So to give some more concrete examples, for the invention example, historically academics basically said you really don't need protection if you have a machine invent something because machines don't care about patents and wouldn't care about incentives. And that's certainly true, but the people who make, use, and own machines care about financial incentives and patents. And if it turns out that machines are going to do a better job than people in some areas of inventing, that's something we really want to encourage. It's something we want to encourage if we care about patents because they help generate socially valuable invention. And if pretty soon in 10 or 20 years, a drug company has a choice of going to a machine to find a treatment for COVID or going to a group of people, it really shouldn't matter in terms of encouraging innovation, which one of those options the company uses. But if they can only get a patent for one, it's going to discourage them from using what might be the most effective option. So I argued that we ought to protect AI-generated output that's patentable without a traditional human inventor or author in the case of copyright, because it will incentivize innovation or the generation of creative works. And of course, it wouldn't work identically. The AI doesn't have legal personality. It wouldn't know what to do with a patent, but the owner of the AI could own the patent the same way that most patents are owned by employers. I don't know if you want me to stop there or go through a couple other areas.
That was quite interesting. I think if you have other issues that were important, I think that it would be great to hear about those as well. Because I think the increasing intersection of law and technology is something that has been spoken about a lot. And while there is a lot written on it, it's I think developing a lot. So everything that's coming out now seems to be new, and there's something a new perspective in how the law can deal with technology and kind of stimulate innovation apart from just regulating it.
No, that's a good point. And the law has historically struggled to catch up with technology, which can be a real problem because technologies like AI both have the possibility of generating a lot of social benefit, but also a lot of risks from things like, causing flash crashes in the stock market, causing political manipulation, people being injured by robotic technologies. So it's important that in advance of these technologies developing, we have regulatory frameworks ensuring that they're developing in the right way. And we do already have regulatory frameworks for AI. It's just frameworks that were developed without AI in mind. So to take another example, if you look at the tax system, and I will admit to not being terribly familiar with the Indian tax system, but in the US and the UK anyway, when you employ someone to work for you, you have to pay a tax on top of that person's salary. Medicare and Medicaid surcharges in the US are national insurance contributions in the UK. So, one area where people here see automation at work is when you go into McDonald's. It used to be you had a human cashier, and now you have some human cashiers, but you also have a bunch of automated kiosks or tellers or cashiers, and you can put your order in there. Well, when McDonald's does that, when they replace a person with a machine, They don't have to pay tax for having the machine do the same job. They do have to pay a tax for the person doing the same job. So that is one way in which tax policy is subsidizing automation without really intending to. And it gets more complicated, but there's a variety of other tax benefits that machines but not people get as workers. So you can accelerate deductions for capital equipment and some types of software. Employers don't have the indirect burden of taxes that are on people, which they pay for employees because they have to pay them wages commensurate with their future taxes. So in short, we have a tax system designed to really favor machines over people, which is problematic because it means that a business might not automate because it's efficient and just to save on taxes. And that isn't something that kind of benefits everyone. The other major problem with our tax policies with AI is that robots don't pay taxes, which sounds kind of ridiculous. But in the United States, 90% of federal tax revenue comes from payroll taxes and from income taxes, which are largely labor-based. A very small percent, less than 10%, come from corporate taxes. So when McDonald's automates that job, we lose that person's income tax, we lose payroll taxes that would have been paid on that person. And if McDonald's gets a little bit more profitable, a relatively small amount of that money gets remitted as taxes. So we have a tax system that's very set up for labor taxes rather than capital taxes. And that's a problem if we get machines putting a lot of people out of work. It's going to be a particular problem with COVID because we're having high unemployment rates that are going to emerge. We're going to have a recession or a depression. And at the same time, we have this whole new good reason to automate, which is to avoid transmitting COVID. But it's going to put a lot of pressure on our tax revenue. And the government's going to need a lot of money for financial stimulus, retraining people, and for social benefits. And so the book argues that, again, we would be better off if we had a system that was more neutralist between people and machines. Now, some people have suggested you would actually go literally tax a robot, but that's a bit problematic. First, it would have a lot of administrative complexity and gamesmanship because what's a robot? What if a robot isn't replacing a person one-to-one? What about business models that are legitimately more effective with automation? And so I think a better way to achieve neutrality would be to fundamentally rethink how we tax businesses versus workers and labor versus capital, right? And right now we like to tax labor because we think, well, labor will keep working no matter what, but investors may stop investing if their taxes are too much or they'll move to other jurisdictions. But that's really been suspect reasoning for a very long time. And even if we had slightly higher taxes for capital in the US, there's still lots of reasons for people to invest here. And that's really an argument that's just a race to the bottom. And you'll see, everyone doesn't rush to invest in the Cayman Islands, even though they don't have corporate taxes. So the solution to this, rather than taxing robots, is taxing capital more broadly and eliminating taxes on human workers like payroll taxes that make it more difficult for them to get employed in the first place. The book also...
Very astute, I think, observation. Yeah. Yes, sir, go on.
I should take a break, so it's not a 45-minute lecture.
No, but it is a very, very interesting, especially I think that's something that at least in India hasn't been explored too much in the context of AI and technology. And even moving beyond just AI technology and its interaction with law has led to various issues such as antitrust or freedom of speech and expression. So in that sense, how do you think that diverse legal systems across the world should deal with such issues? And what is the regulatory perspective and the approach that you think is the need of the hour?
Well, indeed, as you point out, there's a whole lot of challenges brought up in new contexts from these new technologies, including antitrust and the ability of, companies that aren't Google to compete in the market, or companies abusing dominant market powers, and freedom of expression and automated decision making. And so it isn't just, one thing we have to be looking for. I think, a good starting place and what my book is arguing for is a new principle of AI regulation. I think a good starting place is to agree on, fundamentally, what do we want out of these technologies and different bodies of law? And, there is a lot of effort going on right now to promulgate best principles of AI regulation. The next and more difficult piece is looking at specific legal areas and deciding how best to implement that. So, for example, the antitrust area is a lot more complex in terms of what constitutes a dominant position and what's abuse and what sort of data needs to be shared with competitors. And also there's proprietary intellectual property issues associated with sharing, for example, the data that companies may need to be competitive with that. It is also difficult, as you point out, that there is an important international development, area to this. So, for example, with providing, and sorry for screaming kids, but there is COVID and we're not robots yet. The international harmonization is important, particularly in something like intellectual property. So, for example, if you had an AI generate a cure for COVID in the US, under US law, that wouldn't be protected if you didn't have a traditional inventor, right? Other jurisdictions might protect that. So Israel, for example, doesn't require a human inventor to be disclosed in a patent application. You might have an area where you have a patent in some countries, but not others. And, I think that's particularly relevant for India, where there has been kind of an ongoing international debate about access to medicines and what the right level of patent protection is. And India didn't provide patent protection for novel pharmaceuticals before TRIPS, and that really seemed to be a position that benefited India fairly well at the time. We may have a divergence of different approaches in different countries based on who's leading with AI, who wants to provide that sort of protection, who doesn't. And I think the answer to, what's the right approach is it's very complicated, and there's really several levels of regulation that should be going on. So there should, of course, be individual regulatory efforts by codes of conduct in industry and by good corporate practices, but there will always be bad actors or a difference in opinion between companies and the public about what constitutes good action. So, there do also have to be, aside from soft sorts of regulations, some hard regulations coming out of governments, both incentive-based and command and control of, these are some things that we just don't do. The risks are sufficiently great. The benefits are not there. And then at the same time, countries should be participating in an international dialogue about, what are the best practices in this area? Where is it particularly important that we're aligned on things like IP protection, on things like, military applications of AI technologies? So that's a broad answer, but it's a broad question.
Yes, I think it was a very interesting answer, especially in terms of how we have to change our entire approach to technology and understand the individual needs of different sectors, but also just have an overall regulatory system. And while speaking, your research work has been not just limited to AI, but also on intellectual property and particularly pharmaceutical patents and trade secrets, like you mentioned. So according to you, what is the most effective way to handle disputes arising out of misappropriation of trade secrets and infringement of patents? For that, like I mentioned before, you are an arbitrator with JAMS. So in that capacity, could you provide us a brief overview of how life sciences disputes pan out and how they may be different from general commercial disputes?
Sure. Well, again, it's a little bit difficult to generalize, but as a general matter, most life science companies or most universities or most stakeholders in the life sciences industry really aren't in the business of litigating things. Litigation is very expensive. It's very destructive. It's counterproductive. It keeps people from engaging in commercially useful activities because they're tied up in litigating things. There are some exceptions for this, like originator pharmaceutical companies, prefer to sue as much as possible generic companies where they have grounds to do so. So, those sorts of disputes are unlikely to resolve as amicably as others. But for the most part, partners who have falling outs in the life sciences are really looking to get commercial business deals back on track. Or if a deal has fallen through, they're looking for a way to resolve it quickly, efficiently, and with certainty, and then to move on to getting back to their core business. So I think life sciences disputes are one particular area in which alternative dispute resolution, mediation, and arbitration has particular value. Arbitration tends to be, and is usually, depending on the discovery rules being used, much cheaper and faster than court cases. And that is particularly the case both with international disputes, so where you may have an Indian life science company and an American life science company, or an Indian university and an American university. International litigation is very difficult. international arbitration is much simpler and also is more enforceable often, even in national courts. And then much faster. Courts have multi-year backlogs sometimes. And now with COVID, it is, we still haven't gotten really jury trials back on track yet. And in the US, when we have jury trials, they're first going to be given preference for criminal matters. So while the judicial system in the US is really still figuring out how to do this, ADR has very quickly moved online, and now everything almost is online dispute resolution. At JAMS, we're doing about 3/4 of our cases online. On top of that, there are often very difficult technical issues with arbitration and mediation in the life sciences. And so parties have an opportunity to select their neutral party, and they can find someone who has the expertise to understand, what the issues are, which could be very difficult to explain to judges who don't have a background in the area or to juries.
Yes, I think the need for technical experts is definitely something that is unique to any technology-related dispute. And moving on to the how you've written a lot about balancing access and innovation. And you mentioned this earlier as well, how it's important to balance both access and innovation in the context of pharmaceutical patents. And now this issue has gained prominence in the contemporary context when the world is dealing with novel coronavirus, and multiple organizations are consistently working towards developing an effective vaccine. So could you highlight some of the access-related issues with respect to the potential COVID-19 vaccine, especially with respect to patent law?
Sure. And I don't think that COVID-19 has really changed the access issue so much as it's really brought it up to public consciousness. And that is an issue that, for example, India has been fairly active on the world stage of promoting access with things like, provisions of Indian patent law designed to prevent evergreening and some prominent court cases, for example, for Gleevec. But basically you get a trade-off with patents, or a social bargain, we call it sometimes, the idea being that, we want these to incentivize innovation. So we think there will be underproduction of certain things like COVID vaccines without intellectual property, because we think that, well, particularly in the pharmaceutical context, the pharmaceutical industry claims it costs about $2 billion and takes about 8 to 10 years to get a new drug approved. And once a drug is approved, at least with traditional pharmaceutical drugs, it's often very cheap and easy to make it after the fact as a generic drug. And so we think that the right framework for this under patents is that we give someone a 20-year monopoly, then they can recoup some investment that they've made with, originator pricing, and then generics will enter the market and the prices will fall. There's a lot of challenges related to that. One of the challenges on the originator side is that if it takes 8 to 10 years before a drug is approved, you've lost half of your patent life. So they additionally have some exclusivity, marketing exclusivity associated with approvals. And one drug now can be protected by many patents. And so, for example, Humira, which is the world's best-selling biological drug, has, dozens or hundreds of patents on it now, even though it's been on the market for more than 20 years. So some people think that's okay because you have, these new patents or on new formulations of the drug or extended release versions, or companies are investing in finding new uses for the drugs. And others think that this is an abuse of the patent system because one is extending their monopoly for more than 20 years. There are, and then there's an important international dimension to it, which is one, a lot of this research has traditionally been done in countries like the US and in regions like Europe or Japan. And that other countries basically then, according to one narrative, are free riding on some of the innovation being done in those countries if they aren't paying a fair share for using the drugs domestically. And in another view of it, some other countries really can't afford the same sorts of prices being paid in places like the United States for drugs. And if we required something like that, then, you wouldn't have access to drugs in places that really need it. India traditionally has been very generics heavy and very strong on the angle of promoting access, although more recently there are some Indian originator companies that are doing some exciting work. So there isn't necessarily a right answer to these questions, but as COVID enters, it is going to be critical when we have a vaccine, what does it cost? And can countries like India produce a vaccine on their own or under a compulsory license? Do they have to pay for a vaccine to an American company that's manufacturing it? And what if you don't have 6 billion doses of the vaccine? What if it's very difficult to produce and you can't get it in scale? Could that be grounds for companies in India making these sorts of things? So, those are a lot of the issues associated with access. And, patents incentives are certainly imperfect for many of those reasons. And it is important to have international dialogue on this to make sure not only that we can innovate, but also that the benefits of those innovations are shared broadly, because it does few people good if only a select group of people are getting a COVID vaccine.
Yes, that is quite true. And I think you mentioned how under a compulsory license, you could have greater distribution. But that is naturally an exception, I believe, in situations like the current one with COVID. So do you think that a compulsory license in the current context would be a solution, or would it be something that is more nuanced and there are other factors that go into deciding something like this?
Well, I think both. It is a potential solution, but it also depends on things, right? And it also depends a bit on the national situation. And under Indian law, a compulsory license can be granted, but only in certain special circumstances. That's also required by TRIPS. One of which is a public health emergency. Another one is a patent holder is not exploiting a patent in India. So, for example, if you had a patent on a vaccine or manufacturing process, but they just weren't making it in India or selling it in India, that is one potential grounds on which a court could issue a compulsory license. And then there may be some technical barriers to it also, right? Depending on how complex the vaccine is to make, there may be difficulties in actually doing it, even with the patent rights. But, I suspect the vaccine industry in India is sufficiently sophisticated, they'll be able to figure out. And so I think, at the end of the day, it is quite likely you're going to have a legal challenge around, whether or not that sort of thing can be done under compulsory licenses and the terms on which, a license may be granted now, right? So that also is a factor in this, right? Is the American company offering a license? What are the terms of the license? What would be reasonable? What would be a reasonable compulsory license? I think, the U.S. really hasn't done this before in the way that India has, and India has still done it relatively modestly. But, I think it is a potential solution, and we're really going to have to see when we get a vaccine, what that vaccine looks like and what manufacturing for it looks like.
Yes, that is quite true. Like you said, there are several factors to consider and to determine how practical this could be. And thank you so much. You've touched upon so many unique issues with respect to technology and law, from taxation to patents. And this has been a very, very insightful conversation. And especially with respect to, I think, the taxability of workers and the impact on those kind of issues was very unique, at least for me. So thank you so much for covering so many diverse issues. If you had any concluding remarks, we'd love to hear them.
Oh, concluding remarks. Well, thank you so much for having me. It was a real honor, and I really appreciate the interest. Well, so that's the book and the thesis of the book. I guess I might just mention, because we hadn't talked about it. So we're also filing some legal test cases, including in India, trying to see if we can move the debate forward about AI regulation and AI legal neutrality. So, rather than just academically writing it, to combine the practical aspect, I assembled a group of patent attorneys, and we have worked together with Dr. Stephen Thaler, who has invented an AI named Davis, which has invented without human inventive skill directly. You have two inventions, one for a fractal container, a beverage container based on fractal geometry, and one for what we're calling a neural flame, which is a light that could attract human attention, for example, in emergency situations. And we filed for patents on these two inventions in patent offices around the world. WIPO, the World Intellectual Property Organization, published our PCT application naming the AI as the inventor. And we're now trying to see whether or not that sort of invention can get protection. We've listed the AI not to provide the AI with rights or credit or acknowledgement, but to inform the public of how the invention was made and to keep a person from taking credit for work done by a machine, because we think that would devalue what it means to be a human inventor. and the AI's owner, we're arguing, should own its patents. So those applications have been rejected in the US, UK, and Europe, but we are appealing those decisions. And we have filed recently in India. And I have been told by Indian colleagues that Indian law is a bit more pragmatic and flexible about this sort of thing. And so it's going to be very exciting to see what happens with those.
Yes, that is extremely interesting, the fact that you are currently in the process of applying for these patents and appealing the decisions. And I think that does give your experience a very unique combination of both practical understanding as well as your academic experience. And in the context of India, we are in the process of, I think, having a data protection law, and hopefully we'll have greater regulation and laws pertaining to AI as well. So I think on a concluding note, we do hope that there is, like you said, a more pragmatic approach to tech law and AI as well. And thank you so much for taking out the time to talk to us. It has been extremely insightful. So thank you so much, sir.
My pleasure at any time, and thanks again for having me.